Hello. Hi. In this video, we are going to discuss about the continuation part of crash course. This was a second class, which we are in this video we are discussing particularly about fundamental rights. Okay. We will take fundamental rights as a two sessions because we have to see it is in a broader way. Okay, in depth we have to see this fundamental rights because it's a definitely going to ask it concept. It is repetitive and definitely one or two questions are going to come in every year. Okay, straight to when we come straight to the topic, the fundamental rights we have taken from the fundamental rights as a concept. Okay, we have taken from American Constitution. Okay, everyone knows it. It is also known as it is also known as Magna Carta of India. It is also known as Magna Carta of India. Okay, fundamental rights comes under part 3. Okay, it is comes under part 3 of the constitution. Sometimes it might ask the questions such as fundamental rights are under part 3, part 4, like there is asking the questions the part 4 DPSP, like the questions are asking in a jumbled manner. Okay, fundamental rights, who it's not a permanent. Okay, matlab permanent rights are not an absolute one, but it's a qualified right. It can be amended. Fundamental rights can be amended, can be taken out, even can be taken out or even can be included by the constitutional amendment act. By the constitutional amendment act, fundamental can be taken out also. Okay, so it is not a permanent nature, it is not an absolute one, it is a qualified one. But means it has certain restrictions of fundamental rights, not, it is not an absolute one. It's essential. Fundamental rights are essential for all-round development. Okay, this statement has this type of ask questions are asked in previous years papers. Okay, essential for all-round development. Okay, now what the fundamental rights talks about, it is talks about political democracy. Okay, it talks about political democracy. Who will defend the fundamental rights? Article 32 writs, we say the article 32 writs. Article 32 is particularly, yes, the Supreme Court is the defender of the primary defender. Supreme Court is the primary defender of the fundamental rights. If the fundamental rights are violated of any person, he can directly approach to the Supreme Court. Okay, other than the fundamental rights, he can't go directly to the Supreme Court. He has to go certain district courts or certain high court. Okay, but fundamental rights, he can, if the violation of fundamental rights happen, he has to directly, he can approach to the Supreme Court itself. Okay, what is the limitations? Okay, fundamental rights acts as a negative rights. Okay, it acts as a negative rights. It acts as negative rights. It has limitations. It gives limitations upon executive and as well as legislature. Means what it says that executive arbitrarily cannot punish a person. Matlab executive arbitrarily cannot take out the rights, fundamental rights of a person until unless it is mentioned in the law. Matlab if he violated the law, then only a person can be punished. Legislature also the same thing. Legislature directly cannot take out the fundamental rights. Okay, fundamental rights is also part of basic structure. Okay, it acts, fundamental rights acts against both state as well as private actions. It matlab it will work for both state as well private, not only for the state actions. Okay, both can be there. Now when this comes to article 12, what is article 12 says? Article 12 said is a part 3 of the constitution. It talks about the state. Okay, article 12 talks about the term state. But the previous question is asked in 2021 exam. I think it asked that about the state. 20 or 21 it has asked about the state. Okay, what is the meaning of the state? Matlab, if a state should have at these 4 features, then only it can recognize as a state. What is the 4 features of a state? Define a territory. Matlab, in any definition, if these 4 words are included, then only it is recognized as a state. Define a territory should be there. people should be there, government should be there, it should be sovereign, okay, it should be independent, matlab it should not be under any domain in nature. Define territory, people, government, sovereign, these four include features of the state, okay. Now definition of the state, in definition of the state, what which were the organs were included definition of the state? Government, okay. Government, whether it is state, whether it is a central, whether it is a state, whether it is a panchayat or municipality, we regarded it as a state, okay. The PUs, government PSUs, also regarded as a state because it is under the state also, it is itself. The private body working as an instrument of the state, matlab working under the state, or PPP partnership working under the, it comes under the state, okay. Next, the three organs, legislative, executive, judiciary, these three we regarded as a state, okay. These three regarded as state, but by the state, judiciary in administrative capacity, okay. In administrative capacity it is regarded as a state, okay. Judiciary, normal functioning of the judiciary, what is the providing the law, okay, given the justice, it is not an judiciary delivering is justice is not a state, but judiciary acting in its administrative capacity, it is a state. Matlab the recruitment process, whatever the judicial administrative recruitment process, okay, administrative functionaries, these are all comes under the state, but the judiciary itself won't comes under the state, okay. Matlab the, when the judiciary acting in its capacity as a justice, matlab as a justice provider, it won't comes under the state, but as administrator it comes under the state, okay. You may get an example that I said the private the government institutions comes under the state. For example, the government universities comes under the state, but the private universities not a state. Private universities won't come under the part of the state, but it acts, private university acts as an independent bodies, it won't come under the state, okay. Yeah, the UPSC body, it comes under the state, sir. Yeah. And then next one, the next article 13 talks about article 30. Actually, article 13 has given doctrine of judicial review. Implicitly it has given, it has expressed doctrine of judicial review, which in article 32 was for Supreme Court and article 226 for High Court, okay. These two rights, these two articles which provides writs, okay. Matlab fund article that which provides writs, matlab if any right is violated, or we can approach these two courts, okay. If any law, if even the law also, if any law made by the legislature or executive, even the executive also, executive laws means the rules, the framing of the rules is a part of the executive. If any laws are made by the executive or legislature, the whole, the law, whether it's a constitutionality of the law is reviewed by the judiciary. The law the law is inconsistent with if the law is inconsistent with fundamental right, then the law is void, mother, it is nullified. If any law violated the fundamental rights, then it is nullified, okay. Matlab we say that fundamental rights are basic structure, matlab it is violating of the basic structure. If violating the basic structure means it is void. Now the laws comes which were the laws comes ordinary laws, which were made by the parliament or a state legislature. Ordinances of the president can give ordinances, governor can give ordinance of president or governor. Executive actions, matlab framing of rules, giving orders, and non legislative sources, okay. Matlab non legislative sources, matlab executive sources, whatever it may be. If these all are comes under the state, but constitutional amendment constitutional amendment is not a law. Means we make law by the process of by taking the constitution into the account. Amending or giving amendment of the constitution, amending matlab we are inserting something in the constitution, matlab it won't come under the law, okay. This is what the article particularly says about, okay. In exam, the questions can be asked on judicial review based on, are there what are the process of the law, okay. Next question, when sorry next topic, article 14, Next article, article 14. Article 14 talks, it gives two parts. Article 14 has two parts, which is equality before law. Equality before law, which we have taken from the British Constitution, and the equal protection of law, which was protection of law, which was taken from American Constitution. Okay, which was USA is regarded as the American Constitution. Now, in Article 14, equality before law, there are certain principles of equality before law. What happened? Whatever there. Absence of any special privilege, matlab no one has given the special privileges. Ordinary law of court, matlab, for example, if a shopkeeper, if you know, if a shopkeeper, his law is violated, matlab something, whether means his fundamental right is violated, or whether his property rights are violated, then he can approach to the court. Okay, मतलब अगर प्रॉपर्टी राइट वायलेट हो गया, वहाँ पर कोर्ट को चलेगा, मतलब द डिस्ट्रिक्ट कोर्ट और सबॉर्डिनेट कोर्ट्स को चलेगा. और even the richest person also, if his laws are violated, he has to approach only to the courts which has capability to take certain cases. Okay, agar a particular person is rich, it does not mean he can go directly to the Supreme Court for the violation of the law. Okay, everyone is ordinary law of the code, everyone is before ordinary. No person above the law means every person, whether it's even the president, whether the prime minister, is also below the law. No one is above the law. Okay, this says that it is a negative concept. Okay, equality before law is a negative concept, because what is saying the absences, matlab you cannot, everyone has to be equal, but it is not giving any positive note, it's giving a negative note. Okay, it was equality before the law, everyone is equal, is same. Equal protection of law, what is there? Equality of treatment under equal circumstances, matlab if both were the same, then treatment should be in equal circumstances. Okay, equality of treatment under equal circumstances. Next, same laws to all persons, matlab the law which is applicable to the richest person, it is applicable to the even the poorest person. The law which is applicable to the poorest person, the same law is applicable even to the richest person, as well as the law which is applicable to ordinary person, the same law is applicable to even the prime minister also. This is what same laws to all persons. Like should be treated alike without discrimination, matlab for example, if someone is violated, so constitution is violated by someone, or a law is violated by a person, a judge or a legislator cannot say that he is my nephew, so I am going to leave him. ऐसा नहीं होगा. Okay, like should be treated alike without discrimination. Okay, this equal protection of law talks about a positive concept. Okay, the question framers might keep in mind and frame as in a jumbled way. Equal protection of law, it is talks about positive concept. Equality before law, it talks about negative concept. Okay, this we have to remember it. Okay, next, article 14 forbids class legislation. It permits reasonable classification of a person. Okay, but equality before law or equal protection law is not an absolute right, sir. It's not an absolute right. They have certain privileges, certain exceptions. Okay, article 14 has certain exceptions, sir. Did you get my point? It has certain exceptions. Means for president, for governor. Okay, for president or for governor, or even for a member of parliaments or a member of legislative assemblies. Okay, councils or Rajya Sabha members, for them they have privileges. Okay, they have privileges. Okay, for example, president and governor, when they are bearing the office, they cannot, they against them we cannot make criminal charges against them. Okay, even the civil charges also only after 2 months of giving the notification period, then only we can make civil proceedings. We cannot make criminal proceedings in for president and governor. At the same time, whether MP or MLA, when they are in the parliament session or the legislative sessions, okay, a court cannot call them for attending the court hearings, okay, proceedings. They have given certain exemptions, okay, matlab before 40 days of the session, or completing after the 40 after the session, they have certain period times. And the same time, if the foreigners who were coming, diplomats were coming, UN body members were coming, they have separate privileges, okay. They will separate privilege enjoys by them. Even this even this this is what the classification of person, okay. Plus, next, it is but the classification is of a person based on the intellectual differentiation. It should not be in an arbitrary sense. The rule of law, what it talks, the rule of law talks about, it has the concept is given by A.V. Dicey. The concept is given by A.V. Dicey. The rule of law, Supreme Court says that rule of law is a basic feature of the Constitution. Rule of law, basic feature of the Constitution. Equal equality before law is a part of the rule of law. Equality before law is a part of rule of law. Okay. Now, absence of what is says rule of law is absence of any arbitrary power and equality before the law, as well as there is a difference between the concept which given by A.V. Dicey and the Indian. The first two statements are right, and the third statement is different. Okay, what is in India? In India, constitution is a source of individual rights. But when it comes to British, individual rights are source of the constitution. Matlab, individual rights came after the um, land. The land is a source of the individual. There is a land is a source of the constitution there. Okay, they have given primacy to individual rights. But in India, individual rights as taken from the constitution. Okay, here there is an exception to the article 14, that is when article 31c comes, matlab it 31c related to give the justification to the DPS. When article 31c comes, article 14 goes out, matlab article 14 wiper nahi काम नहीं चलेगा. Okay, this is what this thing means. It gives priority to the DPSP article 39, 39 subclass B and subclass K. 39 subclass B subclass K 3 plus article 31c comes, article 14 goes out. Okay, now it has given primacy to the DPSP. Next article 14. What is article 14? Article 14, sorry, article 15. What is article 15? Article 15 says that states shall not discriminate against any citizen. Not discriminate against any citizen, everyone knows, on the grounds only on religion, race, caste, sex, place of birth. This only 5 1. Religion, race, caste, sex are place of birth. But the differentiation, the discrimination on the other ground is that at the same time state can discriminate the person on other grounds, is not prohibited. Matlab, apart from the religion, race, caste, sex, place of birth, the state can discriminate. Okay, for example, by making the qualification, educational qualification, on the basis of educational qualification, it can be discriminated. Okay, like this there. Next, public now again in article 15, it says that the things which are public funded, the public funded such as wells, tanks, roads, okay, wells, tanks, roads, it can be utilized by everyone, and state cannot discriminate against this. Okay, against whether a person private or whether the person is a state, no one can discriminate by using the wells, and the water and the water what can I say, bathing tanks. Okay, like this we cannot discriminate, but there is an exception. Okay, matlab the remaining the state can discriminate. For example, if someone some if public if public restaurants are there, public parks are there, okay, everyone has to be included in it. Whether it's a private, when it comes to the private hotels, okay, like the hotels, like no cannot be, matlab it cannot be discriminate, okay, against the state. But when it comes to trainer, it's not an absolute. Okay, if wells, tanks, roads are restricted by the private persons, it is violated, state acts against him. Okay, exceptions there in article 15 also there is an exception, because we startingly we said that no article is an absolute article, everyone is qualified. Okay, no article is even permanent also. Exceptions: special provisions for women and child. There is special provisions can provide for women and child, and special provisions can provide for socially and educational backward classes. Okay, in public institutions as well as private institutions, public educational institutions as well as private educational institutions, but except माइनॉरिटी एजुकेशनल इंस्टीट्यूशंस. ओके, इसमें नहीं होता है. प्राइवेट में, पब्लिक में स्टेट कैन प्रोवाइड स्पेशल प्रोविजंस रिलेटेड टू द सोशली एंड एजुकेशनली बैकवर्ड क्लासेस और फॉर SC ST. ओके, नाउ नेक्स्ट article 16. What is article 16? Article 16 talks about equality of opportunity in public employment. Equality of opportunity in public employment means state cannot act against, state cannot prohibit a person against, cannot prohibit a person against religion, race, caste, sex, place of birth. Apart from the same in the article 15, there were two more terms which were descent and residence. Okay, descent and resident, resident of a particular state or descent of the particular state, matlab is staying there. Now what happened then? Parliament, but there is an exception. Even every article has an exception. Article 16 says that, parliament can make residence as a ground for certain employment. Matlab parliament can make residence, but the state cannot make. Sir, this statement has to be noted. State cannot make certain obligations. Okay, as a resident as a ground. Okay, but state can provide a fair okay, parliament can only make resident as a ground for the certain employment. The state can provide reservation for backward classes who are not adequately represented in public services. Okay, if cannot be represented in public services, then state can provide reservation for the backward classes. Next, a law, for example of the religious bodies. For example, if we can make a law, parliament can make a law for the religious body as a ground qualification ground. What is the qualification ground? The person who belongs to the same religion only can be appointed for the particular religious bodies. Okay, like this can be, law can be made. It is not a violation of the article 16. Matlab in a temple, if there is a position of a priest, for an employment of a priest. Okay, the law should be made such a way that only a priest, matlab uh, only a piece only a, sorry, only a priest cadre can only, priest person can only applicable for the particular job. Matlab the same religion has to be there. Okay, this is what this law says. Next, article 17. What is article 17? Article 17, abolition of untouchability. Sir, this is the one right which is absolute one, sir. Matlab in whole fundamental rights, article 17 is the absolute one, as well as in article 25 there is 25 subclass A, there is a subclass 1. there is uh, it is also an absolute one. Okay, we will discuss when we discuss article 25. Now article 17, it abolition of untouchability acts against both private as well as state. मतलब if when state discrimination happens, मतलब the government state discrimination happens as well as the private person also discriminating, then the for the both it can be punished. Okay, it is but the concept of untouchability is not defined in the constitution. To implement this abolition of untouchability, to give it enforceable, there is a act has made protection of civil rights act 1955, protection of civil rights act 1955. It talks about the, okay, it gives protection against the untouchability. Okay, but the untouchability as a definition didn't defined even by the constitution or by the act also. Okay, now abolition of untouchability, there is an exceptions is there sir. absolute मतलब इसका मतलब ये नहीं है right to abolition of untouchability. मतलब अगर if a person, if a male person is just holded a female hand, मतलब she refused it, इसका मतलब ये नहीं है सर. Untouchability, you can't make you can make an case on her like this. It is an untouchability that she refused to hold my hand or holding her hand. ऐसा नहीं होता है सर. Okay, it has certain laws. It does not cover social, there is exception that it does not cover social boycott of a few individuals. मतलब कोई भी बंदा है सोशल बाइकआउट कोई बंदा के ऊपर, मतलब द पर्सन हैज हार्टेड द सेंटिमेंट्स ऑफ द people, they can boycott him. मतलब if the person has done something wrong in particular, the mostly it is happened in the villages also, even still now also it happens in the villages. Okay, it does not cover the social boycott is as an untouchability ground sir. Does not cover social boycott of few individuals or their exclusion of the religious services. If a person has violated certain religious practices or has done certain wrong things in the religious institutions, he can be terminated in the religious services. Okay, it does not mean it comes under the untouchability. Okay, now the person convicted of the offense of untouchability, okay, must matlab offenses convicted matlab his the jail term has given, is is disqualified for election to the parliament or state legislature. matlab a member of parliament and the state legislature can be disqualified on the ground of untouchability. Okay, on the ground of offenses made under untouchability. The offenses refu- offenses such as refusing to sell goods or render services to any person. मतलब on the name of untouchability, if you didn't sell certain if a shopkeeper if a public shopkeeper doesn't sell goods or given services to the person, इसका मतलब यही है वो untouchability नीचे आएगा. Okay, yeah. Now there are certain conditions also, we are not taking the whole conditions because the remaining all are general, you know about it, because these were the terms which whatever I picking in this video about, there is a much chances of skipping it or just you didn't given certain priority to the particular sentences. Okay, the remaining sentences it's a generic sentences, everyone can make it. Okay, the questions may frame in by taking these type of sentences. Okay, now next article 18. What is article 18 is saying? Article 18, abolition of titles. Okay, article 18 talks about abolition of titles except military and academic. Okay, except military and academic, matlab it is military and academic titles based on merit sir. It is based on merit, it's not a based on by birth, it is given based on by merit. matlab doctorate दे रही है, he can use a doctorate. Okay, as a prefix. Military titles such as Paramaveer Chakra, okay, Sudarsh, Paramavir Shaurya Chakra, okay, these type of titles were given in the military. Okay, The lieutenant colonel, it's also lieutenant is also, sorry, lieutenant, it's also given, okay. But these type of titles which was given by merit basis, it can be used, but the titles which was the remaining, apart from the remaining, it is all are abolition. Now, prohibition of title. Prohibition of title, there are certain grounds, okay. Prohibition of title matlab, a citizen or a foreigner, a citizen or a foreigner, okay, there are certain a citizen or a foreigner prohibits from the conferring any title, okay. Matlab, whether a person in India, whether he is a Indian citizen or foreign citizen working under the Indian government, matlab, he cannot receive titles, as well as the same thing, he cannot receive title from the foreign state, okay. He cannot receive title from foreign state. For example, foreign office of a profit, foreign office, if office foreigner in office of a profit, matlab working under the government organization, he cannot take the titles given by the foreign country, even the foreign country, without the consent of a president, okay. He should give the, we take the consent of the president. By taking the consent of president, he can take the title, okay. For a foreigner, it is eligible. Then the question will be framed such a way, without a consent of a prime minister, like this the questions, it is a president, sir, okay. Don't confuse on it. Next, the foreigner office cannot, except for cannot hold titles, okay. There's no citizen or foreigner of office of profit cannot accept or present emoluments or office without a consent of the president. Even with a citizen or a foreigner, if he has getting certain emoluments, certain presentations, certain emoluments, certain office from the foreign country, without the taking the consent of the president, he cannot take it, okay. Now, this was article 18, which talks about titles. Mostly there might be a chance of asking the question on titles, okay. For example, every year we release Padma awards or Bharat Ratna awards. Padma awards or Bharat Ratna awards are not recognized as a title, sir, because these both are given based on the merit, sir, okay. Matlab, the service to the provide to the nation, based on this, these awards are given, but there is a condition that these Padma awards cannot be used as a suffix or prefixes, okay. It cannot be used, okay. This can be received, it cannot be used, but this cannot be seen as a titles, it cannot be used as a titles. It is not an against, it is not a violation of article 18, okay. Did you get this? Now, next, article 19, freedom of speech and expression, right to freedom, okay. It comes under right to freedom. Till now, article 18, till now we have seen right to equality, okay. Right to equality we have seen. From article 14 onwards, we have seen right to equality. The question may becomes right from which article to which article it comes under right to equality. Under right to equality, which articles will come? Article 14 comes, article 15, 16, 17, 18. These comes under right to equality. Now, next, we entered in, after completing 18, we entered in article which is right to equality. Sorry, right to equality we finished. Now, right to freedom, okay. Right to freedom. In right to freedom, from article 19 to article 22, sir, okay. Article 19 to article 22, right to freedom, we are seeing this. Article 19, freedom of speech and expression. Article 19, freedom of speech and expression. Sir, recently the Supreme Court in the Supreme Court has for example, Kerala High Court has given that right to internet as a part of Article 21, but the Supreme Court has given the right to internet access as a part of freedom of speech and expression. So it comes under Article 19, okay. Right to internet access. There might be a possibility of getting this question, okay. Now, next, in Article 19, there are subclasses A, B, C, D, E, F, okay. These were the subclasses. Now article A, subclass A, what it says that matlab there are 6 rights. First one, freedom of speech and expression. The second one, after by expression we form an assembly. After the assembly we form an association. After association we move with an association. By moving we reside and settle in certain places, and after the resettlement we practice any profession there. Okay, but article 19 is not an absolute one, sir. There are certain restrictions for every sub part of it. Okay, it is also one of the lengthiest article. After the article 21, it is the lengthiest article. Okay, article 19 acts only against state. Okay, but if it's not act against a private individual, it's only against the state. Why? Now we will discuss one by one. Just article 19 available only to the citizens. Okay, even this article available only to the citizens and share and shareholders of a company. Okay, and shareholders of a company, citizens and shareholders of a company. We all study till the citizens, we will remember it. Okay, but we even remember, but not for foreigners. Okay, foreigners we यहाँ तक हम सब को ध्यान में रहता है, but after this these sentences we miss when we are reading. Shareholders of a company, article 19 is applicable, but the legal processes companies and corporations, article 19 is not applicable. Companies and corporations, article 19 is not applicable. These part sentences we are going to miss. Okay, just remember this. Next, when it comes to part 2, assembly, there has a limitations such as section 144 of CRPC. Section 144 of the CRPC says agrees that criminal procedure code gives that magistrate can restrain an assembly meeting. Magistrate can restrain an assembly meeting. Okay, due to the danger or the health issues or the safety or disturbances of the public, he can restrain the assembly or meeting. Okay, now section 141 of IPC, section 141 of the IPC, what it says that if 5 or more persons assemble, okay, it restrict, if these persons restrict the execution of any law, मतलब इसे violation होगा. Forcefully occupy property of someone, कुछ if someone's property is occupied, or commit any crime, okay, or forced to do any illegal act, मतलब if they are forced a government officer to do an illegal act, ऐसा करना गलती होगा. अगर if they proceed in the criminal crime, it is also violated. Okay, threaten the government itself. Law, if our officer is executing the law, if these persons are stopping it, matlab it is a violation. For example, we can say that during the COVID-19, during the COVID vaccine, okay, the officers are distributing the vaccines, but if an assembly has if a person is assembled to stop the particular distribution of the vaccine, matlab it's a violation. Matlab section under section 141 obviously it is against the law. Okay, now next, मतलब इसको पनिशमेंट दे सकते भी है. Now next, association. After the assembly there is association. Association means such as cooperative unions, political parties comes under association, partnership firms comes under association, societies comes under association, clubs comes under association. We mostly the clubs, the societies, this is where we will mostly see in the cities. Okay, these associations comes under. Now the right to start an association, but also continue with the, not only right to start an association but also right to continue with association also comes under article 19. Okay, we can start an association, we can continue with the association. The questions are such a way that कंटिन्यू करने नहीं होता है, यहाँ पुल स्टॉप दे देता है, बट इट कैनॉट कंटिन्यू, इट कैनॉट मेक ए कंटिन्यू एज ए स्टेटमेंट, ऐसा क्वेश्चन पूछने का चांसेस होता है, इट गलती हो जाता है, ओके, बट ऑल्सो कंटिन्यू विद द एसोसिएशन. नेक्स्ट, association covers negative right, not even the, it also association also even also covers negative rights such as not to form or join an association. If a person, if an employee is working in an organization, he don't want to join particular organization, his choice it is, okay. These right also is negative rights also there in article 19. Now, right to obtain recognition of association not a fundamental right. मतलब अगर एक we started an association, now we are continuing with the association, but we didn't recognize it, हमको recognize करो को fundamental right ऐसा नहीं होगा सर, okay. That is your problem if you didn't recognize it, okay. Now next point is profession. Profession में क्या होगा? State can carry trade, business, industry as a monopoly. मतलब if state is entering in a certain profession, मतलब as a monopolian or as a as a combined collaborative with the private, okay, there is no objection, okay. The for certain profession there is no objection, sir. Even the association, even the movements, everything in the profession there are certain limitations, sir. मतलब for example limitations such as the professions such as we can say that provisions such as sex workers not allowed to stay in every area, sir. मतलब they can't stay in every place, मतलब they will give separate place, they can be there, it is legally, it is accepted there, it cannot be practiced in every area, okay. Certain restrictions are there. For example, forming an association, for example police cannot form an association, okay. And the same time the movement, matlab sir, we have the right to movement. Even in article 19 is a violation of fundamental rights, sir. A movement means, sir, no sir, ऐसा नहीं होगा. If article 19, if a person is in entering into another's homes, ऐसा नहीं होगा sir. Or if a person entering in the tribal areas, it can be restricted, sir. There are certain professions which were restricted in tribal areas, sir, okay. There are these type of restrictions still is there. It did not violation of the article 19. This is what we are going to say. Now next, article 20. What is article 20? Protection in respect of conviction for offences, okay. Article 20 and 21, article 20 and 21 cannot suspend even during emergency, sir. Even during emergency also, you may not understand, just listen it. You cannot suspend even during emergency period also, okay. Article 20 and 21. What is the article 20 says? It's a protection in respect of conviction for offences, okay. Protection against arbitrary towards citizens, foreigners, okay, illegal persons such as companies, corporations, okay. It protected against whole citizens, foreigners, persons, companies, corporation. What it says that article 20 says that no ex post facto, okay. There are three grounds, it contains three provisions. No ex post facto law. वो दिस नो ex post facto law मतलब if a crime has done on Feb 2 there is no law on it. If Feb 10th they made a law, the new law has made, okay. You if there is this law, if this new law has made, you cannot punish him based on this law. Till there is a Feb 2 there is a law, you can punish only based on this law only, okay. This means this is no ex post facto law. This principle works only for the criminal cases, sir. This principle works only for the criminal cases, criminal laws or conviction sentence, not for even the trial also, okay. already convicted a person for the law, there is a new law which increases his sentences. Okay, agar if a person is jailed for 3 years, after the new law it says that the punishment is for 6 years, you cannot make it retrospective law, you cannot implement on the criminal cases, but these can be implicable on civil cases, sir. The retrospective law can be implemented on civil cases. No double jeopardy. No double jeopardy on another ground. No double jeopardy means dual, for a single crime you cannot punish twice. Okay, but this punishment, a person, if a government officer has violated, has done certain law is violated, he is punished by judiciary, as well as he is punished by the department as a suspension, as well as he is scolded by his home also. These three won't come under the double jeopardy, because judiciary is not punishing it twice. Departmental suspensions or punishment is a different thing. Okay, it won't come under the judiciary. Now next one, no self incrimination. No self incrimination with the oral or documentary evidences. Okay, these proceedings also only for criminal proceedings only. Okay, now this is not applicable, but this whole, whatever the still now whatever we have seen, this the criminal procedures, whatever, it is not applicable for the preventive detention law. This is not applicable for the preventive detention law. Okay, what is the preventive detention law talks about? Now let's see. The above grounds cannot be claimed under preventive detention law. Preventive detention law is given for the person 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 without we will see this in particularly in article 22. Okay, we will see this particularly in article 22. Let's see this in preventive detention law, we will see in article 22. Okay, now this is not applicable under the preventive detention law, it is only useful in criminal cases. Okay, self incrimination, you may get the question on the self incrimination. In self incrimination, oral and documentary evidences, this is only applicable only to the even the criminal proceedings. Okay, not for civil proceedings. Oral and criminal documentary evidence cannot be taken, but there is an exception for giving thumb impression, presenting, मतलब attending the particular session. Okay, मतलब next, providing material objects. Okay, thumb impression, blood samples. Okay, compulsory exhibition of the body, it is not comes under the violation. Okay, of no self incrimination. ये कर सकते हैं, मतलब ओरल एंड डॉक्यूमेंट्री एविडेंस के पास ही कैनॉट गो नो सेल्फ इंक्रिमिनेशन, मतलब मैं किया था, दिस the person who has done crime is accepting, it's okay. Now next, article 21. What the article 21 says? It was one of the largest article, the protection of life and personal liberty. Okay, the protection of life and liberty, article 21, it comes under, if a state cannot take a person's life, मतलब cannot violate article 21 unless procedure established by law. If anything is against law, if any person has acted against the law, he is punished by the procedure established by law, but not arbitrary sense of arbitrary nature of the state. Okay, this Article 21, Article 21, the cases which was in Gopalan case, what it says that Supreme Court says in case with a narrow interpretation is that Article 21 is applicable only for the arbitrary actions of the executive. Okay, only for arbitrary actions of the executive. But in Menaka Gandhi case, when it comes to Menaka Gandhi case, the Supreme Court again reviewed his judgment and says that both executive as well as legislature, matlab due process of law, it takes the stance of the due process of law. Matlab Article 21 protects against both the executive action as well as states action in arbitrary sense. Okay, by the procedure established by law, by due process of law, state can punish a person, but without this it cannot punish it. Article 21, in Article 21 there are certain articles, words such as right to travel abroad comes under Article 21. We have seen the right to movement, in Indian territory, it comes under the Article 19. When it comes to the travel in the foreign countries, it comes under Article 21. Right to privacy comes under Article 21. Right to choose, which was asked in, right to choose, right to marry, which was asked in the previous year question, it comes under Article 21. Right to privacy, Article 21. Right to free legal aid, it is also comes under Article 21. Okay, this thing should be clear. Now the next article, Article 21A, I am not going to take the whole the whichever comes under Article 21, because the most things like right to health, right to livelihood, right to privacy, right to shelter, okay, right to goods, right to sleep, yes sir, right to hear, right to information, this all comes under the Article 21. Next article, Article 21A. What is Article 21A? Right to education. Okay, right to education, Article 21A, which was inserted in the Constitution, by 86th Constitutional Amendment Act 2002. When it is 86th Constitutional Amendment Act 2002, Article 21A has inserted. Okay, right to education, right to education, which gives a free and compulsory education to all children, of the age from 6 to 14 years. Sir, 6 to 14 years. Why we have taken 6 to 14 years? Till 6 years we have in DPSP has taken in till 6 years. Okay, ICDS, okay, Anganwadis, in Anganwadis we have till 6 years, the children will goes to Anganwadi schools. After from then they comes into the schooling process, normal schools. From this till the 14 years he will get free and compulsory education. Okay, this is the access. Now next, Article 22. What is Article 22? Talks about protection against arrest and detention. In Article 20 we said that we talked about the Article 20, we talked about the conviction of protection against conviction of offenses. Okay, we talking about the arrest and detention. Now convictions बारे में पढ़े थे, arrest and detention बारे में देख रहे हैं. There are two types of detention. Okay, which is, for the first is the punitive detention. मतलब a crime is already happened. मतलब the person has done crime, after that there is a trial as undergone in a court, and then he is arrested, and then he is convicted, and then he is punished. Preventive detention. The preventive detention law says that a person still didn't committed the crime, even without the trial, court trial, even without the trial of even in a court, a person is stopped from committing the crime. Okay, matlab already the police got information that he is going to do sudden damage to the society or sudden damage to the public property. A person will be stopped by the police, and he will be arrested, kept in the jail as a preventive detention measure. Mostly these preventive detention measures we will see during the election. already the persons who are already done as a crime, previously done as crime, mostly they will hold by the police as a suspicious. Matlab preventive detention law can be applicable as a suspicious manner, but punitive detention law cannot be on suspicious manner. After the court's trial he can commit it, but the preventive detention only to the criminal and quasi criminal cases. Okay, it's not applicable to the civil cases. When the civil cases, matlab you have done the certain fraud, it's not applicable, sir. If you done certain fraud, they will arrest you without the trial also. The punish after the trial and convict by the court. Okay, not applicable to these 22, not apply to the aliens, मतलब enemy aliens and civil arrest. मतलब civil arrest कर सकते हैं सर, मतलब फॉरेनर्स को अरेस्ट भी कर सकते हैं, पुनः डिटेक्शन क्राइम करना भी जरूरत ही नहीं सर एनिमी एलियंस को. एनिमी एलियंस मतलब during war period, if India is against certain, if India is, if there is a war between India, there is a war between India and some ex country, matlab these country persons becomes enemy aliens to us. Okay, till officially India didn't have any enemy alien, right? Enemies. Okay, now next, preventive detention. We said just now, preventive detention law, person without trial and convicted by the court based on suspicion. This protection citizens as well as aliens. Preventive detention protection both the citizens as well as aliens. It cannot exceed more than 3 months. Okay, it cannot exceed more than 3 months, but it didn't happen. For example, after this after for example, after the suspension of the article 370, okay, suspension of the 370, most of the Jammu Kashmir leaders were under the preventive detention law. Okay, more than 6 months, more than 1 year also, like this. Both parliament and state legislature can make laws in respect of the preventive detention law. Okay, you may forget of the state legislature also will make laws on the preventive detention law. Now the next article, till now we finished right to freedom. Okay, right to freedom till 22 we finish it. Now right against exploitation, right against exploitation, it comes article 23, 24. Article 23, 24 comes under right against exploitation. Okay, what is there in this article? Article 23 what says? It says that Article 23 says that prohibition of tariff in human beings and forced labor. Okay, Article 23 says that prohibition of tariff in human beings and forced labor. It is applicable to the both citizens as well as non-citizens. Protect individuals not only against state but also private. Matlab if there is human trafficking is happening, okay, it protects. If even the private individual has done also, it is a crime, it's a punished offense. It permits states to impose compulsory service, but there is a limitation, exception, we can say this as an exception. There is an exception that a state can impose a compulsory to the public for public services on a person, okay, even with pay or without pay also. Okay, without pay also. During the war time, state calls to the persons, they have to defend the country, okay, with pay or without pay also. Okay, it won't violate the article 23. This is what article 23 is saying there. Next, article 24. Article 24, what is article 24 says? It is a prohibition of employment of child in factories, below age 14 years. Till 14 years we have right to free education, free and compulsory education till 14 years. मतलब below of 18 years no person can be allowed, can be given employment in the factory. But there is an exception, sir. In every article there is exception that, but the child can participate in non harm non harm employ, such as entertainment entertainment, ओके, एंटरटेनमेंट कर सकते हैं. फॉर एग्जाम्पल चाइल्ड आर्टिस्ट वी हैव सीन इन मूवीज एंड सीरियल्स, चाइल्ड आर्टिस्ट एंटरटेनमेंट कर सकते हैं. ओके, ऐसा चांसेस होते हैं. दिस आर फ्यू एक्सेप्शंस. ओके, दिस इज व्हाट आर्टिकल 14 talks about. Okay, there is a Supreme Court ordered establishment of child labor rehabilitation welfare fund. Child labor rehabilitation welfare fund is said by Supreme Court to establish it, okay, to take care of the child. Okay, this, okay, mostly the questions might formed in these words. Okay, in this we have finished even the right against exploitation. Till we are going to end this session today. Okay, the next section we will take the remaining fundamental rights. Just go through your books and just refer once. It will be in your minds. Okay, it will fix in your minds. Whenever the revision happens, it will helpful for you. Okay, thank you.